This is Defender Radio. Defender Radio is brought to you by the Association for the Protection of Fur-Bearing Animals.
It's the week of March 20, 2017, and this is Michael Howie welcoming you to episode 421 of Defender Radio. Stephen Wise stood up in a New York courtroom to make his case last week. It's something he's worked toward for years, and so far, the courts haven't supported his efforts. But Stephen knows that his clients need him, because they simply can't speak for themselves. Stephen is the founder and president of the Non-Human Rights Project, and his clients are chimpanzees being kept in confinement. The goal is to get these chimps, individuals of a species that experts have long identified as sentient, emotional, and social, out of cages and into sanctuaries. The case is to appeal the failure of the New York County Supreme Court to issue writs of habeas corpus on behalf of two captive chimpanzees, Tommy and Kiko, who were both recently featured in the HBO documentary Unlocking the Cage. Stephen took a break from preparing his arguments for the Appellate Division of the First Department Supreme Court in Manhattan last week to join Defender Radio and explain the background of the cases of Tommy, Kiko, and other non-human animals for whom the Non-Human Rights Project is speaking, why the laws should grant them freedom, and how animal lovers around the world can help. In most cases where a lawyer is representing someone, it starts with the client contacting a lawyer and saying, hey, I need help. Obviously, this case is totally different. So how did you come to represent Tommy? How did that story begin for you?
We are working to change the legal status of non-human animals, as many as we can, from being legal things, who lack the capacity for any legal rights, to legal persons who have the capacity for an infinite number of rights. So we spent many years first looking at the legal systems or the law of all the 50 states and Washington and the Virgin Islands and Puerto Rico and 20 English-speaking countries, including Canada and England and Australia. And what we ended up doing, after all those years, is we put all of the various jurisdictions that we had identified and done research on into a hierarchy. And we on Easter, in Easter weekend of 2013, we decided that we would like to begin with the U.S. state of New York. So instead of having a client come to us and we say we hear what the problem might be and we know where we're going to file suit, we decided to look at the law of the various states, see where we wanted to litigate, and then look for a client. So we chose the state of New York. We knew, based upon the arguments that we wanted to make, which is that New York the common law of New York really supremely values the idea of autonomy, and the cases talk about it almost in awe. How important autonomy is and how much the courts will protect autonomy. And we then had been looking for autonomous beings and animals who we felt that there was a huge amount of scientific research that had been done and that we could show that they were autonomous. So those included then, as of now, the 4 species of great apes: chimpanzees, bonobos, gorillas, and orangutans. 2 species of elephants, African and Asian, and then an array of cetaceans, dolphins and whales. So we knew there were no captive dolphins and whales in the state of New York. So we basically looked at all of the great apes and all of the elephants in the state of New York, and we actually chose, on Easter Sunday, we chose 2 chimpanzees who were living in a roadside zoo named Reba and Merlin as our first clients. And I then, a few weeks later, went out to that roadside zoo and to see Reba and Merlin, and learned that Reba had died a few weeks before. So that left Merlin. So in September, we decided that we were going to file our first suits our first suit in December of 2013. So as we began to file that lawsuit, as December began to come closer, in September, I sent my executive director back to the zoo to check on Merlin, and learned that he had died the night before. So at that point, it was kind of shocking to us that these two chimpanzees, both of them, had died within the next 6 months. So we decided that, we didn't realize that it was that bad for them, and so we then decided that we would identify all of the chimpanzees in the state of New York, and then simultaneously file habeas corpus lawsuits on behalf of all of them. And so we were finally able to identify 5 chimpanzees. From west to east in Niagara Falls, you had Kiko and Charlie. Charlie would die before December. So the third chimpanzee out of the 7 we identified in New York, three of them died before we could even get their suits filed. But that left Kiko alive in Niagara Falls. Then there was Tommy, who we found in Gloversville, New York. Kiko was living in a cage in a cement storefront on a street in Niagara Falls. Tommy was in a cage in kind of a built in a warehouse, kind of a warehouse-like structure on a used trailer lot in Gloversville. And then we found on Long Island, Hercules and Leo were chimpanzees who were being used for experimentation by the anatomy department of Stony Brook to determine how chimpanzees chimpanzees walk with bent legs, humans walk with straight legs, and they were imprisoning those 2 little guys from beginning at age 2 in order to do research on them to determine how humans evolve straight legs. So those were our clients, and we filed suit in the judicial districts in which each of them were living. New York has about 200 Supreme Courts, which in New York are the trial courts, and then geographically they have 4 different intermediate appellate courts. So the cases from Manhattan are called the First Department, the cases from Long Island are in the Second Department, the cases from Central New York are the Third Department, and the cases in the western part of New York are the Fourth Department. So by coincidence, the chimpanzees were in 3 different departments: in the Second Department, Long Island, the Third Department in Central New York, and the Fourth Department in Niagara Falls. So we filed 3 lawsuits on behalf of the four chimpanzees in courts that were in the Supreme Courts, asking each time that they issue an order to show cause, which under the habeas corpus statute, which meant you can do 2 things under New York law, New York habeas corpus law. You can ask that the court issue a writ of habeas corpus or an order to show cause. A writ of habeas corpus means we want you to come into court and tell us why you are imprisoning your prisoner, and we want you to bring the prisoner into court. An order to show cause says you come into court, but the prisoner does not need to come into court. So we didn't want the chimpanzees brought into court, so we did not seek a writ of habeas corpus. We sought an order to show cause under the habeas corpus statute. So all 3 of the Supreme Courts in the 3 different intermediate appellate departments refused to issue the order to show cause, and which we fully expected. However, we did not think we'd even get any hearings on it. It turned out that 2 of the courts, in Tommy's case and in Kiko's case, actually gave us ex parte hearings in which we were there without the other side even knowing what was going on. But all the 3 of them eventually ruled against us. We went up to the Second, Third, and Fourth Department intermediate appellate courts, and that's when it really got to be strange, because the Second Department wouldn't even hear our appeal, saying that we did not have a right to appeal. We knew they were wrong, because one of the reasons we chose the state of New York is that you have the right to appeal. But little did we know that was just the beginning of the New York appellate courts doing really strange things. So we then had our first appellate argument in Tommy's case, and that court ruled against us by saying that Tommy was not eligible for habeas corpus, because in order to be a person eligible for habeas corpus, because only persons are, you have to be able to assume duties and responsibilities that correlate with the rights that we're giving you. In order to have rights, you have to be able to assume duties. Well, we knew that no English-speaking court, at least in the history of the world, had ever said that, and we knew that no jurisprudential writer has ever said that either. And when we actually went through the court's decision, every single case they cited either actually stood for what we were saying, or was just completely irrelevant. And so we just kind of, said that there isn't much we can do right then, but then we went and argued in the Fourth Department on Kiko's appeal, and they agree. But by the way, even though we had lost on this correlative duties and responsibilities in the Third Department, they implicitly disagreed. In fact, in their decision, they did disagree with the Second Department. They said, basically, of course you have the right to appeal. Well, we knew we had the right to appeal. So, but we lost on this other ground. They weren't able to bear duties and responsibilities, even though millions of New Yorkers who are infants and who have Alzheimer's, they can't bear duties and responsibilities either, but they have rights.
Well, yeah, I was curious about that. I was thinking, any disabled persons who are unable to make certain decisions on their own for any number of reasons still have rights.
That's right. Well, you know what they did? Apparently at the end, before they issued the opinion, they realized what they had done. And so they put in a footnote of just 2 sentences that says, don't worry, this doesn't apply to humans, because they said that humans can collectively assume duties and responsibilities. And I kid you not, that's what they said. So, and they didn't explain anything, they didn't cite to anything, they simply said that sentence, and which has been a mysterious sentence, which apparently means that because some humans can, that means even the humans who can't can have rights. It's irrational, but that's what they said. So then we went to the Fourth Department, who also disagreed with the Second Department, said, of course you can appeal. They completely ignored the Third Department, the duties and responsibilities. They did not rule against us on that ground. They ruled against us on the ground that said we couldn't bring a writ of habeas corpus at all on behalf of a chimpanzee, but not because they were chimpanzees, but because we were asking that they not be freed absolutely. In other words, we didn't ask the court to take them out of their cages and throw them in the middle of Times Square. Instead, we asked that they move them to a sanctuary. And they said you can't use a writ of habeas corpus to move you from one place of confinement to another place of confinement. Well, the first place of confinement was a cage. The second place of alleged confinement was a 5-acre island sitting in a huge lake that 25 chimpanzees are living on. And it kind of stretches the imagination to view that as a place of confinement, much less of one that's equal to be locked in a cage. But that's what they said. That's what I said. Things got really weird once we started getting up into the appellate courts. So then we said, okay, we see these 3 really strange decisions. And so we decided, another reason we chose the state of New York is that we knew that we had the right to be able to file suits again and again, that the idea of res judicata, that when you file a lawsuit, you only get one shot at it, and if you lose, then that's the end, that doesn't apply to habeas corpus cases in the state of New York. So we knew that we could then, if we lost, we could then refile them again and again. So we then refiled Hercules and Leo's case, which we had lost because the judges said we didn't have a right to appeal. We now refiled it in the Supreme Court in the only department in which we had not been in, which was Manhattan, in the First Department. And that judge then, she then, for the first time, at least in English-speaking history that we knew of, issued an order to show cause. And she actually then ordered Stony Brook to come into court to give a legally sufficient reason for why they could imprison a chimpanzee. So that was a major, major victory, for us. So we then had a huge fight in court on that. And then 3 months later, she issued an opinion in July of 2015 in which she essentially agreed with everything we had said. But the question was she bound by what the other appellate courts had said? Because she said that there was no law in the appellate court in the First Department that could guide her. So, because there was none, she was then bound by what the Third and the Fourth Departments had said. However, she then said, I'm not bound by the Fourth Department because there is law in my First Department that says you don't have to get thrown out on the street of Times Square. You can go move from one place to another and use a writ of habeas corpus. So she ignored that, which we agree was completely wrong. Because here we have the various courts ignoring the other courts because they're agreeing with us that they're wrong. But she said that it's been kind of a Kafkaesque journey so far through the appellate courts of New York, but we're slowly getting somewhere. And then she said, however, I am bound by the Third Department's ruling that in order to be a person, you have to be able to bear duties and responsibilities, and that chimpanzees cannot. That's what the Third Department had said. And that was even stranger, by the way, when they said that second part, because there was no evidence that chimpanzees either could or could not assume duties and responsibilities, because nobody ever anticipated that for the first time in history they would put that as a requirement for being a person. And so they took judicial notice of this very complex scientific fact, and said it goes without saying, and no way does it go without saying. It's simply not true. And so not only did they take judicial notice, but they didn't even tell us they were going to do that and give us the chance to actually put evidence in front of them. So she basically said, look, I don't agree with them, but I'm a lower court, though I'm sitting in another department. I'm still bound by them. So you should go back to them because I'm bound by them. So we then said, okay, we're now going to start litigating up in her appellate court in the First Department. We then quickly filed Tommy's case again, and then Kiko's case again in her court, and she said the same thing. Look, I told you I'm bound by the Third Department, but we had to go in front of her in order to take the case up on appeal. So that's what we're doing now. We filed all three. We appealed all three cases: Hercules and Leo's case, Tommy's case, and Kiko's case, asking the court, except we haven't moved forward on Hercules and Leo's because they were removed from the state of New York in 2015, which we allowed them to do because the place that they were staying, which was in the basement of the computer center at Stony Brook, was so horrible compared to even the awful place that they were going to go to in Louisiana that we thought it was immoral for us to try to get an injunction keeping them in the basement of the computer center. So that case and it's not clear that once they leave the state of New York, have the New York courts then lost jurisdiction over them. So we don't want to get into that fight. So we haven't moved forward with that appeal, though it's still pending in front of the court. But we then move forward with Tommy's case and move forward with Kiko's case. Both of those are then being heard on Thursday. And what we're asking is that the court instruct the lower court judge that they don't agree that you have to have duties and responsibilities in order to be a person for the reason of a writ of habeas corpus, because in order to do that, you're either being arbitrary by simply saying this doesn't apply to human beings, or if you're being rational, then it does apply to human beings, and they just stripped millions of New Yorkers of their rights to sue for under habeas corpus. So we ask that they set their own standard and instruct the court that having to have duties and responsibilities was not a requirement in order to be a person for the purpose of a writ of habeas corpus, and that our backup position, even if they do say that, we filed 60 more pages of affidavits from Jane Goodall and 6 other experts showing how chimpanzees routinely bear duties and responsibilities, both in their communities in the wild and when they're involved in language work, which they have human chimpanzee communities. And so we're asking that it be remanded, sent back to the trial court, and have her not be bound by what the Third Department had said, and then move forward on our habeas corpus hearing. So in a big nutshell, that's what we're doing, and that's why.
Well, and it's very confusing to listen to. You've done an excellent job explaining it, but it's not as easy as Law and Order makes it out to be.
Oh no! Oh my God!
Like you need some of this. Like you need a 45-second closing statement, a commercial break, and then come back and have a resolution. That's how it should be. But it seems like, from the extreme layman's perspective, that the judicial system is struggling with the fact that no one has told them what to do, and they are making it up as they go.
That's right, and they understand that it's never been done before. And we've had at least one judge say on the record, look, this is great stuff, but I'm not going to be the first one to do this. And we understand that judges, there are some judges out there who don't want to they don't want to stick their neck out, and there's some judges who do want to be the first one to do it, or will be the first one to do it if justice requires. And we think that Justice Jaffe, who's the one who said, look, even though I don't agree with what the other court had said, I'm still bound by them. We believe that she might be that first judge who, if her appellate court says, look, you're no longer bound by them, now you're bound by us, and we say that's not what you need to do, at that point we're ready to go in and make our arguments, and we think if we make that she may actually be the first one within the United States. By the way, since we brought the cases, there were lawyers in Argentina, and actually I was there in Buenos Aires last May. There were who basically brought a writ of habeas corpus on behalf. They brought a habeas corpus case. They kind of modeled their case on what we were doing in the state of New York, and they brought a habeas corpus suit seeking the release of a chimpanzee named Cecilia from the Mendoza Zoo, and then have Cecilia sent to a sanctuary in Brazil. And in November, the judge issued the writ of habeas corpus, found that Cecilia was, quote, a non-human person, unquote, ordered her release from the zoo, and sent to the sanctuary in Brazil. So now it's happened once. So now we're basically asking the judges. This is the second time in the world now, Judge. We're asking you to do that. The first time in New York, first time in North America, but another judge now has done that based on the similar arguments that we were putting in front of you.
Well, and there is precedent with legislation, is there not, to recognize non-human animals, or I should say, non-human animals as non-human persons.
I don't know of any. There are kind of vague, sometimes statutes or constitutional provisions saying like nature has rights, or animals in the animal kingdom has rights. But we in those countries, we haven't really seen them specifically apply to a specific animal or a specific species. So the only case that we think has really succeeded is the Cecilia case. Okay,
so I might be falling prey to Facebook because you see the headlines of India declares.
India. That has been. They said that India declared that dolphins were persons.
Yes, that's the one.
That is not. Did not happen, and I've given up trying to correct people because it'd be a full-time occupation. You go back. If you go back to what the Indian government released, what they said what they said is that they were no longer going to build dolphinariums or allow dolphins to be kept in captivity. They said that, and here's the critical sentence, some experts think that dolphins should be non-human persons. But they never say that they accept that, or that that's going to be their governmental policy. They simply note that some experts say that. Now, that might be a hint to the world that that's what they would like to believe, but all they do is say that. They never say, and we agree, or that's going to be the policy of India. They don't follow it up and kind of close that circle. So it's not really clear why they put that in, except as kind of able a hint to the people of the world that they're moving in that direction. But that's the only thing that's ever come out, and that's clearly not saying that we, the government of India, as opposed to some experts, did declare that dolphins are non-human persons.
Well, everyone heard it here for the 100th time. That India story is not true. So thank you for correcting me, and I will take up the mantle.
Oh, I wish it were.
Yes, I'll take up the mantle.
I wish it were true. Yes, but however, the Cecilia case, is true, and we are moving. We are trying to, get consistent, rational decisions from the courts of the state of New York, which we think ultimately will end up in our favor. It doesn't mean that they will. It's possible that we could lose. Some court simply says, like the Third Department, hey, they're not humans, therefore they don't have persons, without feeling the necessity to actually explain why that would be. We are working hard so that that sort of thing does not happen. But we indeed have seen the Third Department say, in their 2-sentence footnotes, well, all of this doesn't apply to humans, which to us, that's the exact bias that we're litigating against. so it's
well, and it very much is a bias too, because as you've noted, there is mounting evidence, not just with chimps, but with various mammals.
Oh yes,
that there is culture and intelligence, sentience, emotion.
We have, it's not that what we're saying. We've put in 160 pages of affidavits. We have gathered the evidence about the complex cognition of chimpanzees. We've probably put it all into one place. The 9 experts from, including Dr. Goodall, and then from experts from Japan, Sweden, Germany, England, Scotland, and the United States have together put 160 pages of affidavits in, detailing in excruciating detail the complexity, the cognitive complexity of chimpanzees, showing how they are autonomous beings, showing how they assume duties and responsibilities. So the facts, they would have to ignore all of those facts, or simply say, look, that we don't really care what the facts are. We're just biased in favor of humans. And of course, our argument is we have been there before. At one point, there were there's a habeas corpus case that we rely upon. From England in 1772, which I wrote a whole book about called the Somerset versus Stuart Case, where for the first time a black slave in England said, I'm a person who can bring a writ of habeas corpus. And Lord Mansfield in 1772 for the first time said, yes, you may, slavery is so odious that the common law will not support it, and I free you on a common law writ of habeas corpus. That was the first time that ever happened. Then in 1879, we bring up a case where there was an Indian chief, a Ponca Indian chief, named Standing Bear, and he was taken by the U.S. Army away from his land and brought to Oklahoma, where he was on a reservation. He didn't want to be in Oklahoma. He came back to Nebraska, where his tribal lands had been. He was then imprisoned by the U.S. Army. His lawyer then brought a writ of habeas corpus, and the U.S. government opposed it on the ground that an Indian could not be a person who could not file a writ of habeas corpus. And the judge said, I don't agree with you. He is a person. And so, we've been there where people simply try arbitrarily to say, I'm sorry, he's black, he's not a person. And the courts eventually said, no, that's wrong. Or, I'm sorry, he's an Indian, he's not a person. No, that's not true. He's wrong. And so we're saying now's the time that there are non-humans who are also these extraordinary beings, and there's no non-arbitrary reason why they should not also be persons, at least for the purpose of vindicating their autonomy and having them be able to not live in cages and in prison anymore, and being able to live an autonomous life.
Well, I frequently hear, and this, as our audience knows, our 2 primary campaigns are about ending the commercial fur trade and promoting coexistence with wildlife. And there are lobby groups who stand against us, and there is one politician from Manitoba who really doesn't like me, and called me an extreme radical in Parliament one time, even though I think I just wrote him a nasty letter and I got called a radical. But anyway, and he is...
When that's happened to me, I usually send them a thank you note for identifying me by name. I had someone once who criticized me by name in an op-ed piece in the New York Times, and I sent him an email thanking him for doing that.
Well, yeah, it's for
promoting
the cause.
Spelling my name right. I appreciate that.
But these individuals, they see a mass animal rights conspiracy, and this is not hyperbole on my part. They say if we stop, for instance, testing cosmetics on animals, then the next thing you know, everyone in Canada will be eating tofu.
Well, you know, that's in law. It's called the slippery slope argument. And in the last case when we went in front of Justice Jaffe in the Supreme Court in the state of New York, in New York County, in Manhattan, the Attorney General of New York made that exact argument. And Justice Jaffe, in her opinion, said, I reject the slippery slope argument. If the litigant in front of me is entitled to justice, he'll get it. And we'll leave it for the next judge or the next judge or the next judge to look at the facts that are in front of him or her, which I think is the right way to look at this. It is, period. It's the right way to look at it.
You can't dream up consequence that may or may not come.
And we have to remind the judge, look, Judge, we're here asking that this chimpanzee, Tommy, be given the right to bodily liberty that is protected by a writ of habeas corpus and be freed from his prison and sent to a sanctuary. That is what the case is about. That doesn't mean there won't be later cases involving other animals or right? Who knows? But all we are here in front of Tommy, liberty, habeas corpus, free him, send him to a sanctuary. That's what the case is about, and we don't want you paying attention to the other side, who's telling you that somehow the case is about something else.
Yeah, and what about the argument that you are elevating a non-human animal to be equal to a human?
I don't even know what that means. What? I don't. It's hard for me to respond because I don't even know what it means.
But that's something that I've seen is again, and this ranges from op-ed columns through to social media comments of a chimpanzee isn't a person, and you shouldn't try and make them a person.
Well, we're saying yes, a chimpanzee is a person and ought to be a person, at least for the purpose of a writ of habeas corpus. And I said that's where we've been before. We had people like you who said that you shouldn't make black people equal to white people. You shouldn't make women equal to men. You shouldn't make Native Americans equal to Europeans. We have been there so many times, and people like you are always saying, basically, I want to keep the privileges that I have, and I want to be able to continue to exploit those who I want to exploit. And we're saying, I'm sorry, black people are going to have rights, women are going to have rights, Native Americans are going to have rights, and now chimpanzees are going to have rights. And you don't have any good reason for opposing us. You just want to keep your ability intact to be able to exploit them. Sorry, that day is over.
And that's the concept of privilege that I've been learning about in the last couple of years. As a very privileged white man, born and raised in the suburbs, it is shocking how much that permeates our society.
Yes.
This is one of these instances where there is an incredible thing happening, and it is being accomplished by a team of lawyers led by yourself. But what can advocates do? People who believe in this cause, who want Tommy to be given his rights, who want Kiko to be given his rights.
Well, I'm glad you asked that. We now have revamped our website, revamped the way we are dealing with the rest of the world. A year ago, I would have said, you can send us money or you can cheer from the sidelines. But now we have brought on staff. We have changed what we're doing. You can actually take out your cell phone, text 52886, and then type in the word unlock, because and that refers to the film. Actually, I think it's playing on HBO Canada now about our work called Unlocking the Cage. So just type 52886 and type in the word unlock, and then if you'll give us your email address, tell us how we can reach you. We will then work with you to figure out how the best way you too can work with us to obtain legal rights for non-human animals wherever you might be as well.
To get updates on Tommy and Kiko's court cases or any of the other incredible work being done by Stephen and his team at the Non-Human Rights Project, please visit nonhumanrightsproject.org. That's it for this week, folks. I want to thank you for joining us and ask you to please follow me on Twitter @DefenderRadio to get updates about who I'm interviewing and offer suggestions as to what you'd like to hear more about. Until next time, this is Michael Howie reminding you to stay informed and stay strong.